What's up, guys? Welcome to another Rescue Mission live stream. Is this our first Friday night stream? I don't think so, but it's been a long time since we've had a Friday night stream. But the last time we went live, that was Wednesday afternoon, and I said, we're going to have a live stream very soon, tonight or tomorrow, for sure, and have a non-Kristina Karamo stream to talk about current events. And, well, life got away from us, folks, or away from me, at least. There's so much going on, so much work to do for the conventions coming up, and I still want to do a non-Kristina stream because a lot's been happening in the news lately. A lot of Trump-related things, a lot of Tucker Carlson-related things. There was the interview with Vladimir Putin, and I really do want to catch up on Ukraine news because there's been a lot of stuff going on there and related stuff going on in Washington. But that will all have to wait yet again because has Rumble not started the feed yet for me? Okay, well, I am live. I'm live on, there we go. Okay, I'm live on Rumble, Facebook, YouTube, and X. Is that right? Yeah, okay. If I said Twitter and X or not. But we got hot documents today to go over. We have filings in the Kalamazoo case. This is the supplemental briefs that they are giving the judge prior to a hearing coming up this Tuesday. And the judge is going to have to decide whether or not to issue a restraining order against Kristina Karamo and certain people who call themselves the Kalamazoo County GOP. So we're going to look at the documents filed by both sides in this case. Actually, there's the plaintiff side, the defendant side, and there's also a pretty spicy amicus brief. We're going to look at all of those tonight. And at some point soon, we will have a stream that's not all about Kristina Karamo. But this stuff is important. This stuff is urgent because this case might decide a lot about how things proceed at the county conventions coming up, and perhaps even the quote-unquote state convention that's not really a state convention, the district conventions happening at Huntington Place on March 2nd, which maybe I should explain this again for anyone that isn't aware of this, because I've had people recently ask me about this, and people who are not just like random folks, but like people who have been involved in the party for a long time, who don't understand what exactly is the story with the conventions coming up. And so let me just kind of explain. What normally happens in a convention is we have a round of county conventions, one in each county at the same time, and they elect delegates to a state convention. And at the state convention, there will be some things that are done by the delegates, the state delegates elected from all across the state for statewide things. For example, nominating candidates for Attorney General, Secretary of State, Republican National Committee man, etc. And sometimes there's also components that happen at these congressional district caucuses, they're called, within the state committee. So typically within the convention. So typically a state convention will have a Friday night component where people get together at these district caucuses and they'll do district stuff like perhaps elect a district committee chair. And then they will also have a general session the Saturday morning where they will elect their state chair. For example, that's what the last convention cycle was. Now, normally in the presidential primary conventions, you have a district caucus that's a part of the state convention where you elect who your district is sending to the national convention, your national delegates that are apportioned to your congressional districts. And then you have a general session the following morning when the state delegates get together as one body across the whole state, and they will elect, for example, their RNC committee man for a 4-year term. Last time it was Rob Steele. And their national committee woman. Currently it's Kathy Burden, who is not running for re-election. And that's the two components of a state convention. Now, the problem was Kristina Karamo's party is broke as shit. So they have no money. So they couldn't have a state convention. So what they were going to do instead was we're going to have 13 separate district conventions, and let's let the district parties pay for it themselves. And we'll elect our national delegates at these separated district conventions. And then we'll just have them all take a vote on how many people vote for whoever for district, for RNC committee man, committee woman. And they'll just add them up and then we'll decide who the winner is without having a state convention. The problem, well, the RNC says, okay, well, that's all fine except for one thing. Your state convention or the event where you elect your national delegates has to all be in one time in one place. So at Huntington Place, aka TCF Center, aka Cobo Hall in Detroit, is the one place where 13 separate district conventions will be happening. Now, somehow Kristina's people are talking about having a whole bunch of crazy statewide stuff happen, like overthrowing the chair, expelling state committee members, rewriting the rules, the bylaws of the state party, canceling the Republican primaries. We'll talk about that in a second. How they will do that at 13 separated district conventions remains to be seen, but that's what they're going for, folks. And in fact, we have a news story. Before we get to our briefs in this Kalamazoo case, these new briefs, we have a news story from our hero Scott McMahon, the intrepid muckraker who has a news story out today, I believe. Breaking exclusive text messages from Karamo's former deputy chief of staff. I'm not sure if so. This is from Joel Studebaker. There's Joel Studebaker's picture there. He calls him the former deputy chief of staff. I think he means former in the sense that, as in Karamo's the former chair, but he might still be her chief of staff. I don't know. And I didn't know if he's deputy. I thought he was the chief of staff, but I might be mistaken. But anyway, there's the headline. And the point is, this is talking about this item that they were, and we've been through this, so we'll go through it again because it's so important. But there is this proposal, and District Chair Ken Byer put out this video the other day with this image, which they explain is going to be the agenda for this, what they call here in this image, which is a screenshot from a video, a state convention of delegates, which is weird because as we just went through, there is no state convention. There's a bunch of district conventions, but they're calling it a state convention of delegates. So maybe there's some other fantastical event they're thinking they're going to have, where they're going to have a state convention of who knows? Maybe there's something completely unrelated to March 2nd where they're going to do this. But that's what their plan looks like it is. And there's this video. We've been through this in previous streams, so I'm not going to go through all this all over again. Aaron Tuckfield and John Dunlap says Aaron is correct. Says that Joel Studebaker was the chief of staff. Then Lori Skibo became chief of staff, and he became the deputy. Okay, that rings a bell. I'll trust you guys are correct on this. Anyway, so because Kristina Karamo's people are pathological liars, people are coming up and saying, I've heard that they're thinking about this, but they're not going to really do it. This is just what Ken Byer might be saying, but that doesn't mean they're going to do it. And they were going to do this at the January 13th meeting they held, but they didn't do it. So maybe this is an aborted plan, whatever. Why are you fear-mongering, Adam? Why are you saying they're going to do this stuff just because Ken Byer says so? He doesn't speak for Kristina Karamo. Well, here's what Joel Studebaker is telling people in these text messages that just came out. So, and again, this is in reference to this second point on this presentation here. Pass a resolution to close public primary vote and open it to the delegates. This refers to a scheme also called closed caucus. Personally, I wouldn't call it that. I find the word caucus intensely confusing to people because it means so many different things in so many different contexts. And for most people, they think the Iowa caucus, it's not. I'm just saying it's closed. They don't know what that means exactly. I would call it a closed convention, would be my term for it. But some people call it a closed caucus, sure. Whereby the state GOP bylaws are rewritten to allow only delegates, meaning precinct delegates effectively, to determine who will represent the Republican Party on the general election ballot. Voters will then no longer be able to vote in primary elections. Now, again, this might seem kind of confusing, but this text exchange is actually very illuminating. So on February 3rd, a delegate reached out to Bigger Truth with screenshots from a text message conversation that she had with Karamo insider and former deputy chief of staff Joel Studebaker about the closed caucus. This delegate told Bigger Truth she had already witnessed the pattern of intimidation and verbal abuse from the Karamo organization and asked to be kept anonymous. Yes, because they are like the Scientology cult. Because they're a cult. That's what cults do. They intimidate and harass anybody that is either, and especially a former member of the cult, but also anybody on the outside criticizing it. They'll go after you. That's the way Scientology operates. That's the way the Moonies operate. That's the way the Karamo cult operates. And on Facebook says it could be because the MRP is broke and they can't afford to throw a primary. Well, actually, and the funny thing is, the whole thing about the primary is it's taxpayer funded. That's supposed to be the easy way to do it. But then she also says, other than their innate fascist tendencies. Yeah. Well, let's go through this text thread, because there's actually, the funny thing is, this seems to be the extrapolation of an idea that I came up with regarding the presidential primary. And we will look at that in a moment. But here we go. Now, the other thing, though, Andy, your original point, though, is in a primary election, you have to have a candidate that can run a campaign, that can pay for voter contact. That's the thing that they despise. That's why they're so obsessed with the state party, is because the state party is relatively easy to take over. You can become a precinct delegate, just file a piece of paper. Usually that's all it takes. Might have to come in not last place to win your spot as a precinct delegate. You're dealing with a few hundred people, maybe at most, at your county conventions, a couple thousand at the state convention. You can nominate someone like Kristina Karamo for Secretary of State or state chair. You only have to win the votes of a small number of people, relatively speaking, compared to running for U.S. Senate, winning a campaign. You have to actually reach millions of people. It takes a lot of money, and that's hard. And hard work is poison to these folks. Like, they want that's the whole thing about all these patriot schemes, whether it's this or the Convention of States or it's all looking for a silver bullet, an easy shortcut to save our country. God forbid you have to do shoe leather work and actually change the minds of the American people. Anyway, let's well, at this point, Scott McMahon starts describing what's in the text. Let's just read the whole thing, guys. I actually made this nice, easy peasy image that's super simple to read. You can see it right there on the screen. Looks a little tough to read here, but you can just click on it and it will go big. I will put the link in the description on Facebook and Rumble for this video, and you can just scroll down through it. So this is the entire thing. So this is from some delegate. I don't know who the person is. I think Scott refers to her as a she. So that's all I really know. And this is, I believe, February 3rd, he said. So only a few days ago. And some person sends this article in the Free Press to Joel Studebaker. And there's the story here. There's the link to it. What to know about Michigan's February 27th presidential primary. And here is this circled portion of the, let me zoom in here a little bit. This is the circled portion of the article. There's a problem. Remember Michigan's new earlier primary date? Moving the primary forward actually violates RNC rules, which state the only presidential contests before the beginning of March are supposed to be those in Iowa, New Hampshire, Nevada, and South Carolina. So to keep in compliance with RNC rules and hold on to all of the state's 55 nominating delegates, which will be awarded at the Republican National Convention this summer, Republicans in Michigan are also going to hold a caucus-style state nominating convention on Saturday, March 2nd. There you go. That's what they're going to do. You're welcome. I'll talk about that in a second. So the person asks, I don't get this. If we vote in our presidential primary, does our vote get disqualified because we voted before March 1st? And what is the caucus on March 2nd? I'm finding this confusing. See, I told you this caucus stuff is confusing. Will Michigan voters have their votes disqualified and replaced by a caucus vote? To which Joel Studebaker responds, 16 electors selected by the citizens on February 27th, 39 selected by the delegates on March 2nd, total of 55 from Michigan going to Milwaukee in July. That is 100% correct. Good job. But the person responds, what? How did this happen? This is not okay. And so Joel responds, you can blame Whitmer and the RNC. Well, wait a minute. Blame the RNC? How's that? Let's hear Joel out here, and then let's look at what this means. Kristina and the team salvaged the 39 delegates. They wanted Michigan to lose the 39 and only get 16. The delegates picking the other 39 was the solution. Okay, first off, so the RNC has these rules, and the rules are designed to say you can't have too many early primaries. There is a process. Super Tuesday is the big date, and Iowa goes first, then New Hampshire, then South Carolina. Everybody else has to wait. And I think Nevada, they let go early too. But just because the Democrats in Michigan changed the rules, the RNC is like, well, tough. We can't change. First of all, the backstory of this is in Michigan in 2008 and in 2012, the state party moved our primary super early because in those two cycles, Mitt Romney was running. Romney's campaign they practically owned the Michigan GOP because his dad was governor here. They had lots of connections to the Michigan GOP, and they wanted him to go early and get a big boost. And in 2008, they were going to penalize the party, half of its delegates. And then when the national convention came up, they forgave them. So then in 2012, they did the same exact thing again, expecting the same treatment. This time the RNC said, no, we're not making any exceptions anymore. You guys are stuck. And they penalized, I think this time, all of their delegates in 2012 to send a message. We ain't jacking around. You can't go early. So, cuts to 2023. The Democrats are now in power. They can set the primary date in statute. And remember what I said earlier, taxpayers pay for the primary. So if you do anything else to select how you nominate for president, if you don't use the taxpayer-funded primary that the Democrats have now set for February 27th, then you got to pay for it. And of course, the Karamo campaign can't pay for anything. So the plan was, and by the way, folks, this part that kind of pisses me off. Kristina and the team salvaged the 39 delegates. Folks, this was all my idea. I hate to tell you. This is the email I sent, and just to prove it to you, this is the email I sent. Subject line, kill the primary. Sent February 6th, 2023. You find anyone talking about this before I was? Nope. And here's the point. Adam, this is addressed to me. Last week, the Democrats in the legislature voted to move the primary from March to late February of next year. And this was done for twofold purpose. One, the Democrats brown-nosing Gretchen Whitmer, because if somehow Biden gets stuffed in a locker, Whitmer might get an advantage with an early primary state. The other reason was to screw over the Republicans, which is exactly what I said, to screw over the Republicans at the national convention. So here's what we do about it. We don't have a primary. So this was what set everything in motion. And for the record, I regret nothing. Because in the alternative, we would have only 14 national delegates. So we actually got 2 more national delegates doing it this way. There was a process that went back and forth between the state party and the RNC. And this is where they said, okay, well, you have to we still want to have a primary. And so this is where they came with this balance. This is, I think, even better, actually, was to say, let's have some national delegates chosen by primary and some chosen by convention. And this way you won't be penalized your delegates. So we got our delegates back. We actually, therefore, basically just invited ourselves to vote in the Democrats' primary, which would have been great had, say, RFK been on the ballot, but he's not, so that's too bad. But we got our national delegates back. Now, all of that having been said, that does not mean it would be smart to eliminate all primary elections altogether. Now, maybe it would be a good idea to have partisan voter registration and only allow registered Republicans to vote in a primary election. But guess what? They didn't get that done when I was calling for that 10 years ago. So now it's too late. Now we can't do it. And here we are with a Democrat-controlled primary election system. So here is, so that's the longer story to what exactly this was. But here's, so this guy, Joel Studebaker, says the delegates picking the other 39 was the solution. Yeah, and I would say a good solution. This is all fine. I have no problem with any of this, by the way. But then the guy says, so our primary is a sham. And Joel Studebaker says the only one the RNC would accept. No, it isn't a sham. It just doesn't pick all 55. Personally, I think the delegate should pick who represents our party across the board. And here we go, guys. This is the funny part. Because this explosive text exchange was only about the presidential primary. And it was not the delegate, the anonymous delegate in this text thread, who decided to probe Joel Studebaker to get to what the heck is going on with the Kristina Karamo faction. He just goes right into it. He just launches right into it. Oh, no, because here's what I would say. No, it's the best we could do in the situation. We actually get more delegates decided by the primary, but plus we also get all of our national delegates back. The point I would make that Joel Studebaker fails to make here is, guess what, folks? Trump will win all these things. He will win the national delegates, and he will also win the primary. So it makes no difference. That's a good point to make. No one's being disenfranchised here. Trump's going to win, period. So, whatever. But he doesn't make that point. Instead, he goes on to say, Personally, I think the delegate should pick who represents our party across the board. Why do we allow corrupt elections and crossover Democrats to help us? And this person, who is clearly smarter than Joel Studebaker, says, I disagree. Crossovers and infiltrators are everywhere, including precinct delegates. To take the vote away from the people of Michigan and give it to a few is unacceptable. We'll call her Mrs. Smart. Studebaker says, correct, they are everywhere. A political party is a private organization. So what? The current process allows people who are not Republicans to participate and select our leadership. That is asinine. No other private organization does that. We are not taking votes away from the people of Michigan other than to cancel their primaries. Why does the Republican Party and the Democratic Party not allow people to select their Secretary of State, Attorney General, Lieutenant Governor, some other judicial roles? Why do other parties outside of the Republican and Democrats select everyone through caucuses and not primaries? Because they're broke. And because, well, let's go back here for a second. Let's answer this first question, then we'll answer the next question. By the way, I don't know why my nose is itching. That's why I'm doing this, because my nose is itching for some reason. I don't get it. I must need more cocaine. No, I'm just kidding. It's the outside of my nose that's itching. State law, for one thing, state law prescribes that these candidates are nominated at convention. Secondly, it's a terrible process. That's why we have Kristina Karamo as our nominee for Secretary of State. And he's on my good side now because he's been doing some great work in Kalamazoo, but Matt DePerno should not have been running for Attorney General because of certain things he's been filing in some other unrelated cases involving Todd Corsa. That's a story for another day, folks. But nevertheless, the point being, when you run for a statewide office, if you are going to win, you need a ton of money. Now, for some of these other roles, and maybe this is to the point. Maybe this is why. I worked for Tom McMillan when he ran for State Board of Education. And when you are when you're running for an office that is very, very, very huge in geography and electorate size, but also very, very, very low interest, regular, in terms of relatively speaking, who's going to raise more money for their statewide campaign, the guy running for governor or the guy running for State Board of Education? So the idea is we can nominate our candidates for State Board of Education at convention so they don't spend millions of dollars in their primary races. That's the idea, which kind of makes sense for the statewide races. But even that, as I say, has produced bad results because we've also had awful candidates for some of these seats. So why do we do this? Because that's what the law says. That's basically the reason why. And there might be arguments this is a respectable argument, but who in their right mind would say, let's have no more primary elections? Well, that's what Joel Studebaker is saying. So here is what he argues here. Why do other parties outside of Republican and Democrats select everyone through caucuses and not through primaries? Because, again, primaries are taxpayer funded. And guess what, folks? The way that the Democrat and Republican lawmakers have written the law is that only Democrats and Republicans get taxpayer funded primaries. That's basically why. The inconsistency is ridiculous. Yeah, well, that's life. Now, there is a gap here, so I'm not sure exactly what was said next, but it's clearly with not a lot missing here. So he's still explaining they wanted Michigan to lose the 39 and only get 16. The delegates picking up the other 39 was the solution. Yep. So now, again, this person asks, so our primary is a sham? Oh, I already read this. Yeah. So this is, okay, maybe I just didn't compile this image correctly. I'll try to fix that. Anyway, so now Studebaker, of his own volition, goes on to, let's see, is this where we started here? Okay, I'm sorry, folks. I have lost my place here. Let me get back to where I was. So here is where he says, personally, I think the delegates should pick who represents it and who leads it. So he now, even though he wasn't asked to explain this, Studebaker goes on. Our founding fathers created our country as a constitutional republic with a representative form of government, and we are missing the most basic representative form of government, which is the delegates. Really? Because I think most people would say the voters. And that is being exposed through corrupt elections. The bloodbath in the spring and summer of Republicans fighting each other is exasperated by the fact exasperated. But hey, you know what? Might be autocorrect. I shouldn't rip on his spelling and grammar here because that might have been an autocorrect thing. The bloodbath in the spring and summer of Republicans fighting each other is exacerbated by the fact that the Democrats figure out who their candidates are before the primary, and the primary is a rubber stamp by the public. Democrats have figured this out, and we better figure it out too. Are the Democrats canceling their primary elections, Joel? Because I'm pretty sure the Democrats just had a 4-way primary election to fill a seat in a special election for the state house just now. Jason says, I would sure as hell rather have Matt DePerno as AG over drunk Dana. I fully agree, Jason. But that's not the point I was making. The point I was making was Matt DePerno, let's just say he was closed out of a lot of access to fundraising that you'd want an attorney general candidate to have because of certain lawsuits he's filed on behalf of Todd Corser. Again, long story, not a detour I'm going down tonight. Kelly Powell says, why do these people think none of us understand history? Yeah, they're always talking down to you, aren't they? We noticed that. That's the whole conceit of this stuff too. We know better than the voters. We the delegates, the precinct delegates, we know better than the average voters. Anyway, so this gal responds, I still disagree. And I believe it's a way to remove power from the people who aren't in the club but are staunch Republicans. It's another silencing of the silent majority. Yep. There are a lot of people who don't have the passion to become precinct delegates every 2 years. Doesn't mean they don't care about their country. And the person continues, the Democrats/globalists will infiltrate and need fewer players to do their dirty work. So this person is clearly a genuine patriot, to use those terms, Democrats/globalists. And by the way, good point. Good point. Wouldn't it be amazing if Democrats just drop $1 million to get a bunch of people filed as PDs all over the state? That'd be easy. That'd be easy to do. And by the way, folks, guess what? This whole debacle has clued them into that fact. So, Student Baker says there are over 8,000 delegates. By the way, that's an accurate estimate. Some people elsewhere I've seen that say 4,000. It is around 8,000. This would make the delegate role far more important. So, it would allow people in a precinct to truly have their neighbors be their representatives. Do they want that? Go out and knock on some doors. Hey, I know you guys like voting in your Republican primary, but guess what? I'll save you the trouble. I'll vote for you. I know better than you anyway. They'll go over well with them, won't it? The way we have been doing it has been an epic failure. Continuing the way it has been is insanity. So now the other person responds, and removing the primaries from the people of Michigan to a much more concentrated, infiltrated system is also insanity. Some pushback here. And now getting to some piercing questions. Do people have to prove they're Republicans to fill out a form and submit it to the county clerk? Nope. In fact, for the most part, filing to become a precinct delegate is how you prove you're a Republican. Like if you're trying to run for the Citizens Redistricting Commission, one of the only things they can use to prove you're not a member of, say, the Republican Party is to say you're a Democrat precinct delegate or a Democrat elected official. So then Studebaker responds, I disagree with you 100. We deal with infiltrated systems, or we might as well admit we don't care enough. Well, but this is your coping, Joel. Is you're disagreeing with your whole argument is the establishment has infiltrated us with their money. So now this gal says, it's okay that you disagree with me, but are you saying my concerns don't have merit? And Studebaker says, well, I disagree with your concerns. I'm not asserting merit. Okay, fine, fair. So, but this person continues on. What about the silent majority? The Republicans who show up to vote at every primary and every election. What about their rights to vote? Wouldn't they be disenfranchised? Yes. This is what Studebaker callously says. Their job is to make sure they have good delegate representation. Oh, yeah. Yeah, that's fair. That's fair. So, it's not enough for a ordinary voter which they never bother to do, but to look up every single candidate on the ballot, right? State rep. Let me go to the state rep candidate's website, see what he's saying. I go to his opponent's website. I'll check on my state Senate candidate's website. And I go to look. I'll research my county commissioner. I'll research the candidates for for congressman. I'll register my candidates for U.S. Senate. No, that's not enough work for them. No, but much better for them to research Joe Blow precinct delegate. Oh, who's Joe Blow? What's his platform? I'm a constitutionalist. What does that mean? What does that mean exactly? Who are you going to vote for? By the way, and do you think every race is black and white? Like we were talking the other day about the new general counsel of the state party is Mike Bishop. Well, 14 years ago, Mike Bishop and Bill Schuette competed for the nomination for Michigan Attorney General. Who would have been the better Attorney General? I don't know. I mean, in that cycle, I voted for Mike Bishop personally. He was my preference. But could I put my hand in the Bible and say Mike Bishop is a patriot and Bill Schuette is an America last rhino? No, we don't actually know at all. I mean, we do know in hindsight, Bill Schuette was a pretty good Attorney General. So you're going to vote for Joe Blow, John Smith, and Mary Jane for precinct delegate, and you're going to be informed as to how smart they will be in their choices of candidates for these other positions. Are you guys out of your mind? And plus, if you know anything about how this actually works, if you're electing for someone, at a high level office where it's not just the county convention that's going to nominate them, it's going to be the district or the state convention that's going to nominate them. Okay, how is your precinct delegate going to vote? You don't even know because you're voting for the precinct delegate for a 2-year term, not knowing who they're going to be voting for, and they're not going to be voting for the candidates. They're going to be voting for the state delegates. You don't know the personal conflicts going on at your county party that are impacting things. You think the average voter you're knocking on doors knows any of this stuff? This is a recipe for anarchy, folks. Anarchy. Their job is to make sure they have good delegate representation. Oh, yeah, that'll work. This is lunacy. The idea here is we, the party, will tell people who to vote for. So this smart person, Mrs. Smart, says, so does this mean the precinct delegates will be voting on candidates for every elected office like you do for SOS and AG? Yep. I'm trying to get my head around this and how it would get into place. Like a vote on a ballot proposal, everything between delegate and president, ballots at county conventions. Kelly says, respectfully, the vast majority of new delegates still have, I think she means to say, no idea what it means to be a delegate. Yep, that's also true. That's also true. Positions like cross county lines or endorsements, then elections occur district, state. Local positions not fully vetted through the process. Oh, really? Wait, what process? Is this your Communist Party process? Your state central headquarters will have a process for vetting the candidates, all these candidates. They're going to do that for us. You can tell they've barely thought this through. Positions that cross county lines or endorsements. What does that mean? What do you mean they're endorsements? So you got a state rep seat that's in, say, 4 counties. Like my state rep, their district is part Washtenaw, part Wayne, part Monroe, part Lenawee County. How are the party bosses going to decide who our nominee for that race is? Oh, that's right, Zoe. I don't know how you pronounce it. Any Democrat going to be a delegate, easy race to win and take over. Yep. That's how they'll decide. The Democrats will. Of course, that's the idea. So now the person says, so ballots at county convention would be how the changes would be made or the state ballots. I guess I'm confused. No. That's how the process would work. So now they're trying to clarify things. I guess I'm trying to understand how the system would change from everyone voting in the primaries. So now the question is, how are you going to implement this? How are you going to get us out for the primaries, Joel? Would that be put out in a ballot proposal? Would we ask the people of Michigan to take away to disenfranchise themselves? Maybe that's my question better this time around. Yes, now it's clear what the question is. The question is, how do you intend to disenfranchise the voters? Well, it's simple. We're a private organization, the Republican Party is. The party would make the change. All 8,000 delegates vote at the local level. The process is still being finalized. Yeah, because the original plan was to do it at the August convention, but now that Kristina's been removed, now they got to do it at the March convention, don't they? Don't they, Joel? So this person who might be from Berry County, says, so not just 19 PDs like in Berry County, but all the elected PDs would vote. I think there's about 120 in our county right now. Only 38 go to convention, 19 plus 19 alternates. All would vote at the county level for sure. The district and state levels, a decision would need to be made. By whom? I think all delegates should be allowed to vote and allocations applied based on the most recent SOS or presidential vote. That's the way they apportion delegates to state conventions. Samson Miller says, Kristina Karamo is still chair in her dreams. But the process is not locked in yet. Locked in? How's that process going to get locked in, Joel? Still whipping some votes among the Kristina Karamo cult? Maybe you don't have the votes. Interesting. Now, there's a little gap here. I'm not sure. But the person says something about, so PDs can use, there's something PDs can use to vet local candidates, or did I not understand correctly? I think vetting would need to come through forums, fora, where candidates speak to the delegates. You mean like the way people decide how to vote in primary elections? Forums, I think they mean fora, are easily manipulated. Could start with forums, but need a more rigorous approach. Yeah, the more rigorous approach is you swear your loyalty to Kristina Karamo. That's all I got to do. So then who would do the main vetting? Lots to be decided. The most important thing to me is that we stop allowing fake R's like Meyer running in our party. Why? Why not just beat him in the primary? He's being beaten in the primary. You don't think Republican voters remember that he voted to impeach Donald Trump? They voted to overthrow the president? Let him blow his millions of dollars, making Scott Greenlee wealthier. Good for him. So the person says, agree. So is this being rolled out in the county conventions or at state convention? Let's see. Let's see. Is this their plan? Ultimately, state is the goal. There it is. There it is, guys. This is what they want to do at state convention. This is Joel Studebaker putting it in writing. To be voted on by PDs or announced? Good question. Anyway, now there's a gap. And the gap here is after the intrepid reporter, Scott McMahon, made a video, which within a few hours got back to Studebaker. And I can't quite see what was above this, but then it says, please consider what I'm saying to you as a friend. This is too important. Please walk away from politics. I only wish the best for you. Yes, Joel, getting out of politics would be very good for you. You're new to politics, Joel. You're a come lately. You didn't care about politics when Donald Trump was running for president in 2016. You didn't care about politics when Donald Trump was running for re-election in 2020, did you? You didn't care about politics and when the election was stolen in 2020 because you weren't there. You weren't in politics when Barack Obama was destroying our country, were you, Joel? Because in the Kalamazoo County case, you admitted to the judge, you said, I only got involved in politics in 2022. I'm new to this. Well, where were you, Joel? Where were you, Joel, in 2020 and 2022? Until 2022, I mean. You're a come lately, Joel. And you think kicking out the people who were fighting in the trenches to save our country is some kind of act of purification of the Republican Party? So I'll tell you what, Joel. I think you're the cancer in the GOP. You're the one with this revolutionary Marxist attitude, with this cult mentality, browbeating people for not supporting your con artist of a state chair. Wow, cannot trust you. You want to talk to him directly? Looks like I don't need to. You told him everything I would tell him, the same stuff I said above. Stop talking to liars like McMahon, who is working directly with those who want their corruption club back. What would you know, Joel? I am done with this conversation. I wish the best for you. I hope you figure out who you're talking to and that they're using you. Well, there you go, guys. That took longer than I thought. That was a lengthy introduction. So now I got to get to these legal briefs. We have briefs. This is for the Kalamazoo County. You know, let me make this. I can make myself smaller. Make this screen bigger. I should have done that a long time ago. Sorry, guys. This is the Kalamazoo case. This is the case in which Kelly Sackett and the Kalamazoo County GOP, Samson Miller, Fake text. Get real, buddy. Seriously. You guys are retarded. Like when Trump endorsed Hoekstra, that wasn't really Trump. That was his handlers. I don't believe it until Trump says it to me face to face. Jesus Christ. Oh boy. Clearly, but well, it is what it is. Yeah, okay, yeah. Well, then Joel Studebaker can file a suit for impersonation or something. We'll see how that goes, for defamation or something. Get some discovery on this. I'm sure Scott McMahon didn't do any due diligence. Anyway. So, all right. Now, anyway, this is the Kalamazoo case. This is the case where Kelly Sackett, as Kalamazoo GOP chair, and her committee have sued a bunch of people who have been LARPing as the Kalamazoo County GOP, along with suing Kristina Karamo, Dan Hartman, and Jim Kopis, because they held this LARPing session on January 13th, where they supposedly said they recognize these other people as the actual Kalamazoo GOP, something that the state party has no ability to do, except maybe for the purposes of convention. But therefore, there is this lawsuit. And the important thing is that there was a motion for a temporary restraining order against these other people. Rodney Halcombe, misspelled in the caption as usual, and these other folks, because they're going to try to have a convention on the 15th. And it is a problem for precinct delegates that there is a real convention and a not so real convention, and not knowing which to go to could disenfranchise them. So they have had this motion for a temporary restraining order. The judge heard a little bit about this last week, so I'm not quite sure what to do just yet. We're going to adjourn until Tuesday, the 13th, and I will decide then. In the meantime, turn in your briefs, and I will read them carefully. I don't think he read them very carefully before the hearing the other day. And let's see what they say. And so we have 3 briefs now. We have this one, which is the one from the defense, or the partial defense. Some of these people don't have lawyers yet, apparently. There is also a motion from the plaintiffs, or a brief rather, and there is also an amicus brief filed on behalf of multiple county parties. So let's look at all of them, folks. First, we have this is the one filed by the defendants supplemental brief in support of answer to plaintiff's motion for a temporary restraining order, show cause order, and preliminary injunction. We have the caption up here, which we've just read through. Robin Maxon's name. So far, neither party has spelled Maxon's name right anywhere, but that's okay. You got Daniel Hartman's name spelled correctly for once. That is an improvement over the defendant's previous briefs. So there you go. And we have new lawyers. New lawyer in this case, Kelly Howard. You know, when we watched the hearing this past Thursday morning, we saw there was a new lawyer because Dan Hartman wasn't there. And but I don't think it's Kelly Howard. This is ceflawyers.com. This is the law firm that they seem to have hired. Looks like this is a big firm. This is a lot of attorneys they've got here. And this is Kelly Howard. Clearly not the lawyer that was there this past Thursday. This is somebody else. She is apparently the CEO of this law firm, and she is a graduate of Georgetown Law School. So this sounds like a very serious attorney. There you go. Let's see what this apparently very serious attorney says on behalf of these defendants. Now, she's co-counsel along with Dan Hartman for Kristina Karamo, Dan Hartman, and Jim Kopis, who of course are members of the former members of the state committee. And they are part of this case because of their role in trying to recognize these other individuals as the leadership of the Kalamazoo County GOP. And here we have their introduction. By the way, Rob on YouTube says, I will go to county convention and represent the 350 plus voters who expect me to do my best. Good for you, Rob. In the meantime, I will obey Ronald Reagan's 11th commandment. I hope you mean before the convention, Rob. Reagan's 11th commandment is, thou shalt not speak ill of any Republican. That's out the window for this, folks. That is, and this goes to what Senator Richardson talks about in confrontational politics, about how our conservative sensibilities allow us to be trampled over by Marxists. because they abuse your good nature. They take advantage of the fact that you won't cheat in an argument. So they will hurl accusations, they will lie, they will slander, and they do so from the comfort of knowing you won't call them out on their bullshit. Don't be their victim, folks. Call these people what they are. They are Marxist fanatics, and they are pathological liars. If you really look at what they say and what they do, which we'll see a little bit of in this brief, I think, but we'll see. Yeah, Zoe Lee says, no wonder the state GOP is broke. All this infighting and suing each other gets very expensive. Actually, no. That has nothing to do with it. Dan Hartman's been working on this for free. The infighting and suing each other has cost the good guys money. But actually, the reason the state party is broke is because they never raised any money. They looted the federal account. They didn't raise any money for the state candidates. They filed their state filings 6 days late. How much money did they have in the campaign accounts for state candidates across the state of Michigan when they got a special election coming up in 2 months? Bupkis. 25 grand. What they'd raised all year. Nothing. They're broke because they didn't raise any money. They looted the federal account. They raised no money. They took what the National Republican Congressional Committee gave them, and they kept it for themselves. They put it in the administrative account. They paid salaries. They paid for computers. You look at their federal expenses: payroll, parking, meals, computers. They looted what money they had, and they didn't raise any money. That's the reason the state party is broke. Not because it was infighting, because they didn't raise any money, because they didn't want to raise any money, because that's not what their agenda is. Their agenda is to keep the party broke and destroy it on a long-term basis. That's what the agenda is. That's what that entire expose on Mike Labadie was all about. He's a Democrat California operative whose mission is to destroy the GOP and turn it into a cult movement that does nothing but bicker with itself and lose elections. Tim Lawless says we need $200,000 worth of computers. Yep. Yeah, the journalists found that a bit puzzling, didn't they? $110K for Jim Caviezel. Yep. Anyway, so super lawyer Kelly Howland has filed this brief. Dan Hartman is not the signer on this. Wait, hold on. Where's the what do we have here? This is a short brief, by the way. Yeah, here it is. Kelly Howard, the super lawyer. Remember, she is a certified rising star, according to superlawyers.com. So there you go. Let's read Super Lawyer's brief here. The plaintiffs filed this suit to determine the validity of their actions in allegedly removing and replacing defendants Karamo, Hartman, and Kopis from their seats in the Kalamazoo County Republican Committee. What? That's weird. I didn't think anybody was claiming that Karamo, Hartman, and Kopis had seats in the Kalamazoo County Republican Committee. It'd be weird if that's what the plaintiffs had said. Jesus. Yeah. Say that again. This is what this says. Because I'm pretty sure the plaintiffs don't say in their complaint that they filed this suit to determine the validity of their actions in removing Karamo, Hartman, and Kopis. I'm pretty sure that is nowhere in the complaint. But they say, this goes on, they say this case is justiciable, meaning it's not an intra-party dispute, because they've already allegedly removed and replaced the defendants from their seats. Right, because Kelly Sackett removed these individuals from the Kalamazoo County GOP. Therefore, it's not an intra-party dispute. Well, actually, even if she hadn't removed them as members of the executive committee, it doesn't make anyone chair. That doesn't mean you get to, if you're still a janitor at a corporation and you say I'm the CEO, it doesn't mean it's an intra-party dispute to say no, you're not. But there you go. Yet this conclusion stands at odds with the very reason for their lawsuit. Does it? Does it though? Because That doesn't actually make any sense. So she goes on to say, the court to reject their circular reasoning. See this case where circular reasoning was rejected. Okay. How is this circular? I'm alleging, Judge, that these people were dismissed from the party. They held a fake convention, and now they're pretending to be members of the party, which they're not. In fact, they're pretending to be in charge of the party. They're not. They're not even members in good standing of the party anymore. How is that an intra-party dispute? They don't actually explain this at all. If you're going to say something in circular reasoning, show the circularity of it. This conclusion stands at odds with the very reason for their lawsuit. How so? That's not an argument. Moreover, collateral estoppel bars the plaintiffs from relitigating whether the replacement of seats constitutes an intra-party dispute. The court has already found that it does. Collateral estoppel, by the way, means like retrying the same thing over again. It's like the civil version of double jeopardy. The court's already heard this case, Your Honor. Therefore, we can't hear it again. Except it's not. And by the way, the other side's going to have something to say about all these things. So you really got to go out of your way to make this argument, don't you? Because don't you want to anticipate what the other side might say about this? To assert collateral estoppel defensively, a party must show that 1, the issue was actually litigated, and 2, determined by a valid final judgment. Yeah, exactly what I just said. You have to prove that it was the same case all over again. Weird thing is, though, the case last year was the reverse parties. It was Sabrina Pritchett Evans suing Kelly Sackett. So, it would be weird if that'd be the same case, arguing the opposite thing. That's kind of illogical, you know? If the court got you the thing you wanted in the first case, which they did, hence KGOP putting out a press release saying, huge win for KGOP in our case, why would we be suing asking for the exact opposite thing now? Doesn't make any sense whatsoever. Don says, I'm not used to lawyers using contractions. Maybe it's they've, maybe I'm old school. Rob says a super lawyer of contractions. There you go. Anyway, an issue doesn't have to appear in formal pleadings for the parties to actually litigate it. It's actually litigated when it is obvious that the parties have litigated the issue to exhaustion. Citing a case, and again, just citing a case to say that same thing. So, okay, are you gonna show how this was litigated to? Have you shown yet that this is the same case? A valid final judgment for collateral estoppel purposes is one that remains unmodified. And then there's another case citation. Okay, how does that apply to this case? Here we go. Here, the issue of whether the committee's replacements of seats constitutes an intra-party dispute that was already litigated in Kalamazoo County Circuit Court. Wrong. That's not the issue here. The issue here is, who's the chair? In that case, the case last year, the plaintiffs complained, that Sabrina Pritchett Evans complained that the committee replaced their seats in violation of the bylaws, which they failed to articulate. The defendants, who were plaintiffs in this case, argued the claim was non-justiciable because it was an intra-party dispute, because it was. The court entered an opinion and order that analyzed whether the replacement of seats constituted a non-justiciable intra-party dispute and held that it did. So the issue was actually litigated to a valid final judgment. Sure. But that's a different case. And this is the end. Thus, collateral estoppel precludes the plaintiffs from litigating. This is actually even lazier than what the other lawyer, whoever he was, argued last Thursday. It's just, nope, Judge, you've heard this case before. And then the entire rest of this is just a reprint of the old case. That's all it is. That's all it is. It's amazing. That is their argument. Your Honor, this is the same case as the last one. Well, I certainly hope the other side doesn't have any arguments to explain why it would be any different. Let's look and see. Here we have the other side's argument from Matt DePerno, Kelly Halcombe, poor Robin Maxson. Nobody can spell her name right. Oh, well. But this is still an improvement. Some other lawyer, Dave Peters. Who are you, Dave? I have no idea who Dave Peters is. Maybe he was the guy that was there the other day. I don't know. Whatever. Emily Crawford. She's a defendant. Okay. Plaintiff supplemental brief in support of a motion for an ex parte temporary restraining order, show cause order, and preliminary injunction. Table of contents. Yeah, Jason says, now a real attorney. All right, this is a little bit longer. I'm not going to read it word for word, but we will just try to hit on some high points here. First off, table of contents. Oh boy, this is lengthy. 2 pages of table of contents. I wonder if the judge is going to want something to read, is going to go, okay, so these people just look at this. Okay, Your Honor, this case is BS. It's the same as the case last year. The end. Okay, well, that was easy. Next argument. Table of contents. February 15th County Conventions. Issues in this case. I'm sure this is going to be just about why this is so urgent, which the judge already knows, but that's fine. The beginning. Election of executive committee and officers. Republican Party organizational structure. MIGOP cannot intervene in county disputes. This is an important point. So the judge might want to say, you know what, the state party can sort this out. No, they can't. Fake splinter group forms after infighting within the Kalamazoo GOP. Breach of contract. Hey, look at that. Look at that. A claim that, a court might take on in any other context in the world, like a corporate law issue. Breach of contract. Identity theft, fraud, obstruction of justice, tortious interference, and misappropriation. These sound like very specific legal claims. Not just what the Kalamazoo case was last year. Remember the Kalamazoo case last year? Let's go back and look at this. What was this? What was this case? This case involves an inter-party dispute concerning the replacement of seats, press release statements, and removal of delegates. You see anything in here that sounds justiciable? Like, tortious interference with business relations, obstruction of justice, fraud. It sounds like an easy case to dismiss compared to, I don't know, breach of contract. And so here we go. And then there's a section, legal authority. Granting plaintiff's motion for temporary restraining order will preserve the status quo and protect the plaintiffs from the irreparable harm of the fake splinter group conducting a fraudulent competing convention. And there's the elements that you need to show for the restraining order. That plaintiffs likely to succeed. Plaintiffs will suffer irreparable harm. Plaintiffs will suffer immediate and irreparable harm if a preliminary injunction is not issued. The public interest will be harmed. Jurisdiction, conclusion. And here we go. Plaintiffs seek a temporary and permanent injunction against defendants to prevent them from conducting a county convention of delegates on February 15th, recognizing Halcombe, Ileaf, Crawford, or Maxon, or any group called KZoo delegates, aka KZoo precinct delegates, aka Kalamazoo County delegates, as the official GOP. Facts, I'm going to skip over mostly because we've covered these a lot. And this is very similar to what we looked at last time in the original complaint, for example. A lot of this is pretty similar. Oh, Don says, lawyer Dave, this is the guy we haven't seen yet. Must be pretty ancient. My hubby is 74 and his P number starts with 58. Wow, there you go. In the early months of 2023. Okay, yeah, we've covered all this. This is all in the original complaint. Here we go. The issue in this case is relatively straightforward. Whether a group of people can take over a private organization by simply declaring themselves to be that organization. 1, if the group of people are former delegates and former members, the answer is no. This is not an intra-party dispute. Rather, such actions constitute identity theft, fraud, tortious interference with business relationships, obstruction of justice, and conspiracy. 2, maybe the group of people are current delegates and current members. The answer is still no, because now the actions constitute a breach of contract, i.e. violating their bylaws. Under either analysis, the answer will always be no. This is not an intra-party dispute. This court has jurisdiction to hear this case. The temporary restraining order must enter to prevent the defendants and their club from holding a fake and illegal convention. That, by the way, the thing to point out here is, I'm not going to reread this whole thing because there's so much stuff we've seen in the complaint, but the important thing here is they're reestablishing the narrative. What's the other side doing? Judge, don't think about what the facts of this case are. We're just telling you it's the same as last year. It's the same as last year. But looking at this, the judge can go, oh, I see. Oh, so this is what happened. Now I'm hearing a story. What's the other side of the story? Nothing. The other side is, Judge, we heard this case last year. He's like, really? I didn't hear this case last year. Several county committees have filed an amicus curiae brief in this matter, Exhibit 5. They understand the importance of this issue. Affidavits signed by Kelly Sackett, James Charles Koss, Nicole Sable, and Roger Millen regarding the continuing damages are also attached. Oh, look at that. Damages. The beginning. Election of executive committee and officers. And again, we'll skip over this because this is largely rehashed from the original complaint. But here we go. This is an important one right here. MIGOP cannot intervene in county disputes. This court has asked about MIGOP intervention. Put simply, it is not permitted. First, there are no conflict resolution provisions in the MIGOP bylaws. Footnote, the former Karamo administration, attempted to pass a conflict resolution package of bylaw amendments last fall, but they were overwhelmingly rejected by the state committee. By the way, that conflict resolution package, that is the thing that they're trying to do at state convention also, that third thing. That bit about allowing the state party, in fact, Dan Hartman, or the general counsel in particular, to just fire people from county committees. Anyway, second, if MIGOP asserted control over any county or district committee, shouldn't say of the typo, whatever, it would bust the FEC/state contribution limits, resulting in significant fines. There you go. That's a problem. MIGOP has not set up a centralized monitoring system to ensure that all contributions made and received by all county committees, district committees, and MIGOP are collectively within the limits. Such authoritarian control over county parties, i.e. the Karamo agenda, means that MIGOP would be required to report all contributions made to all county committees. So it proved to be both illegal and a logistical nightmare. Yeah, that's why county parties are independent, as are district committees. This is also, by the way, why never until Karamo came to town did any state party ever try to meddle in county party affairs. Why did Karamo party do it? Because A, to distract from the fact they couldn't do anything competently at the state level, and B, because they're control freaks. Fake splinter group forms after infighting with the KGOP. This, again, largely rehashes what we talked about in the initial complaints, as are the breach of contract claims. And so this is going on here. I don't know if we're going to read this whole thing. Identity theft. Talking about, okay, defendants Karamo, Hartman, and Kopus removed from their positions with MIGOP and fired. And yet they had this fake event, the LARPing event on January 13th, which, of course, they get to right here. Karamo, Hartman, and Kopus recognized fake splinter group and the real KGOP. After being fired, Karamo, Hartman, and Kopus held a meeting on January 13th and violated the MIGOP bylaws, recognized the fake splinter group as the KGOP. Hopefully, the judge gives an restraining order against Karamo and all this stuff, too, because that will be very, very bad for their status as the supposed chair and general counsel of the state party, but we'll see. Hartman and Kopus break the law by contacting the Secretary of State. This is election interference and is tampering with delegates that are sent to the National Convention. Yep. I mean, I don't like using Democrat words and things like that, calling this election interference. But whatever. I understand he's trying to be persuasive. Halcombe obstructs justice and attempts to steal bank account by demanding access to KGOP financial records. Defendant Halcombe sent a message to Sackett demanding access to KGOP's private access code to change financial records and access the bank account. Exhibit 27. No need to look at that. We can imagine that, what that would probably say. And then there's the legal arguments. Granting plaintiff's motion for temporary restraining order and preliminary injunction will preserve the status quo. We kind of went through this in the initial application for a TRO. This is pretty well restating what was stated before. Likely to see the merits. Harm will come if we don't do this, et cetera, et cetera. There's some good new stuff in here. If you want, guys, I will put a link for this in the description too, in YouTube and Rumble, so you can read this whole thing, or just pause the video as I'm scrolling through it. But I will post this someplace, and I'll update the descriptions. I'll make sure I do that tonight. So you can read this whole thing too if you want. Jurisdiction. This is important. Defendants raise this issue. The issue that this court does not have jurisdiction because of Height Manus v. Austin, with which this court is very familiar. Defendants have incorrectly interpreted this court's opinion in Pritchett Evans et al. KGOP, v. KGOP et al., to mean that every dispute within a political party is intra-party and non-justiciable. They've concluded, therefore, that violations of the bylaws are completely permissible and not subject to judicial review. This interpretation is wildly inaccurate. To the contrary, part of this case is at least 15 breaches of the KGOP bylaws. In the alternative, this case is about identity theft, fraud, tortious interference, and misappropriation. This case is justiciable because, one, its resolution calls upon the court to decide whether the actions described herein complied with the bylaws or breached the bylaws, or whether additional torts occurred. And two, courts regularly deal with cases involving compliance with bylaws of private associations. Bingo. This case is justiciable because, one, its resolution calls upon the court to decide whether the actions described herein complied with the bylaws or breached the bylaws. Oh, wait. Is this the exact same sentence printed twice? I think it might be. Oh, well. Conclusion and relief requested. There you go. All the foregoing reasons we want what we're asking for. And they're citing this Hillsdale case as well. And see also the Sabrina Pritchett Evans case, finding the court did not have jurisdiction to decide whether the plaintiff did not specifically plead a violation of the organization's bylaws. See the difference? See the difference, Your Honor? In that case, the case they filed last year, they failed to plead a violation of the bylaws. This is our case. We did plead a violation of the bylaws. A little bit different. Now, one more thing, and then we'll call this a stream because my throat's already getting sore. But we also have the amicus brief. And this is a brief of amici curiae. I don't know how you pronounce curiae. Amicus brief, Oakland County GOP. For plaintiffs. Attorney for amici, Margaret J. Kurzweil, Madison Crest Business Law, PLLC, South Lyon. And by the way, it's not just Maggie who has authored this brief, or signed this brief, I should say. This is submitted on behalf of, or with concurrence from, the Washtenaw County GOP's chairman, the Macomb County GOP's chairman, the Gladwin County GOP's chairwoman, the Genesee County GOP's chairman, the Livingston County GOP's chairman, the Jackson County GOP's chairman. Well, those are some big counties, guys. I mean, I can't say conclusively that means it's going to be a blowout at convention, but, you know, Oakland, Macomb, Genesee, Washtenaw, these are some big counties. Anyway, I guess that's not the most important thing. Most important thing is the arguments. And this is a very lengthy, detailed takedown of all of these stupid arguments they've made in the past. Let's start here. Interest of Oakland County Republican Party. The Oakland County Republican Party, OCRP, has a strong interest in protecting the identity and the valuable brand of its Republican County Party. The identity of the OCR, the integrity of the OCRP, its relationship with donors, and the recruitment of volunteers are some of the important functions of a county party that cannot be allowed to be destroyed by those who are disingenuous with their motives. OCRP is concerned that persons who are not members of OCRP may be permitted to set up shop as the official OCRP with nothing more than an intent to destroy the good name, the goodwill, the business relationships, and expectancies of the OCRP throughout the county and even the state. Oh, you think so? By the way, folks, that's what Kristina's lawyers are arguing in this case. Imagine if the Democrats could do that. Imagine if the Democrats could just call themselves your local GOP. Can you imagine the fun they'd have? That's what Kristina's lawyers are asking the court to give them the ability to do, which is weird. Doesn't seem to make any sense unless you understand that Kristina Karamo's motives, or that of Mike Labadie, her handler, are to destroy the GOP. Then everything makes perfect sense. Why would that be? Anyway, where were we? OCRP is committed to the constitutional protections of freedom of association. However, that freedom of association cannot be permitted to allow individuals to wrongfully use the name Oakland County Republican Party for their political activities, particularly when those activities are not congruent with the mission of the official county party. Given the importance of the present matter to the viability of over 83 Republican parties in the state of Michigan, Patty will thank you for that, saying over 83 county Republican parties, because of course there are 83 counties in Michigan, but the Wayne County GOP is split into 3 congressional district county parties. So there you go. Patty, you are welcome on behalf of Maggie. In the state of Michigan, this matter is one of necessity and urgency for judicial resolution. Arguments. 1. The issue between the plaintiffs and the defendants is not related to an intra-party dispute. Thus, this court has jurisdiction to grant plaintiffs' request for relief. Alternatively, even if there is an intra-party dispute, this matter is justiciable. That's interesting, because in this DePerno memo, the argument is, let's see it here. It's here someplace. We saw it. Let me find it here. Just one moment. Here we are. So DePerno's brief says, no matter who these people are, whether they're former members or current members, this is still not an intra-party dispute. And yet in this memo, even if it, let me make this bigger. Even if it is an intra-party dispute, the matter is still justiciable. Kelly Fountain asks, so are we as delegates going to 2 different conventions hosted by 2 different chairs? Probably not. Probably not. Depending on, well, if you're in Kalamazoo, you might be. I'd go to Kelly Sackett's convention if I were you, and you're in Kalamazoo. But no, only in counties where there is this disputation over who the chair is, might there be competing conventions. And then for state convention, who knows? Who knows? I hope this court prohibits Kristina Karamo from continuing to pretend she's the chair, in which case she, I guarantee you, will continue to pretend she's chair and will call some convention someplace. And that'll be great, because then all of her supporters will go to that convention and they can LARP there all they want. But we'll see. We'll see what the courts do. Zoe, you can tell me if it's Zoe or Zoe. I don't know. I usually hear it pronounced Zoe, but I know there's a congresswoman who pronounces it Zoe Lofgren. So I don't know. Can a delegate vote in the primary and what the delegate vote, you mean at convention also? Yes, you can. I will vote absentee. I was supposed to vote absentee the other day, but the clerk didn't have my ballot application handy. Zoe, thank you. And I will also be voting at my county convention. Yes, you do both. You do both. Jason says KK will probably call it a virtual convention. Yeah, because she'll have trouble renting a room. They'll find some way to scrounge up the money, I suppose. But they're going to have difficulty since there's already the convention rules passed by the state committee after Mackinac that say the district conventions are going to be at Huntington. So we'll see. John C. King says the February 13th date for the Kent County case will be important. Unless you're referring to something I'm not aware of, John, you mean the 13th date for the Kalamazoo case. That's what this is. The Kent County case, I think, is not coming up till the 20th. Anyway. So this amicus brief filed on behalf of the Oakland County GOP and also concurred into by other county chairs points out that even if this case is an intra-party dispute, it's still justiciable. Let's see what they say. Brief review on intra-party disputes and justiciability. 1. Intra-party dispute, non-justiciable. Traditionally, courts have been cautious to rule on disputes involving political intra-party disputes. I would have put this section second. I'd have first gone, here's all these examples, Judge, of intra-party disputes that have been adjudicated, that were absolutely justiciable. And then let me show you how narrowly this other category is, but whatever, they start with this one. For example, just a preference for resolution of intra-party disputes has been the form for the respective convention of delegates when the issue is focused on delegate selection or seating. See this case. On the other hand, an intra-party dispute may be related to competing factions of a political party. For example, the Michigan Supreme Court affirmed the decision of a state administrator to require the factions of an intra-party dispute to agree to candidate selections for a general election prior to ballot certification. See this case in which a faction split off, held their own state convention, nominated candidates for public office. Both factions presented their slate to the state director of elections under the same name. Both factions requested certification. The director would only certify that slate of candidates agreed upon by both chairs of the faction parties. Litigation ensued in both federal and state courts. The faction that split from AIP filed in federal court, and its complaint was dismissed. The other faction proceeded with the complaint for mandamus in the Court of Appeals. Secretary of State appealed the order of the Court of Appeals to the Michigan Supreme Court. That court reversed the lower court's order. Man, a lot of confusion here. And noted in its opinion that due to the changes in the state's election code, it was no longer required to put on a ballot more than one slate of candidates for each political party in a general election. Thus, the director of elections correctly left the American Independent Party the resolution of the intra-party dispute. I don't quite follow that. In American Independent Party, both the original party and the faction party were members of the same party. In fact, in their separate conventions, they nominated some of the same candidates for office. Daniel Lawless says, no guarantee that judge rules immediately. No guarantee, but he did say, I'm aware of how important and time sensitive this is. So we'll see. Zoe says, would that mean a Democrat can Democrat take Republican can vote in Democrat primary and Republican delegate vote? SSF sounds crazy. Yeah, I mean, if you are a Republican, I don't quite follow what you're saying, but like, for example, if you are if a Democrat fake Republican, well, okay, well, let me just put it this way. If I wanted to, I could vote in the Democrat presidential primary and then turn around and vote in the Republican convention because I'm a Republican precinct delegate. Yep. And I would have if RFK was still running as a Democrat, by the way, because Trump is going to win the Republican primary anyway. I want to make Biden look bad. That was part of my idea back last February when they wanted to cancel the primary. But unfortunately, that is not panned out. So I'll vote for Trump. Anyway. Although I do like the none of these candidates thing that the people in Nevada voted for in the Republican primary the other day. But that's a whole other story. Anyway. So, see, I think this is getting too technical. I wish this was just saying this is different because you're talking about delegate stuff, et cetera, et cetera. But now we get to this section. In fact, here, let's read this paragraph because it references this other case. Even the removal of county committee members from an executive committee has been ruled in one jurisdiction as non-justiciable because of the reluctance to judicially interfere in an intra-party dispute. See also Sabrina Pritchett Evans. Removal of executive committee member deemed an internal policy matter. On the other hand, an intra-party dispute may be justiciable. The courts have utilized various factors in analyzing whether it's appropriate for judicial intervention in intra-party dispute. For example, determination of a nexus between the intra-party dispute and state action may be sufficient to justify judicial intervention into the matter. In this case, for example, something blah, blah, blah versus Democrats, the two Democratic Party committee members in Philadelphia were removed from their positions for alleged disloyalty to the Democratic endorsee of a U.S. senatorial candidate. The lower court dismissed pleadings filed to object to the committee members' removal on grounds of non-justiciability. Reversing the lower court's decision, the Bettman court noted that the General Assembly had enacted legislation that provided for the constitution of local political committees either through election or appointment. The court reasoned that by enacting legislation that affected the internal composition of a political party, such action bears a direct and substantial relationship to the performance of public functions by the political party. Basically, offices in the local political party were filled by the same process under the same statute as public offices, thus state action. Like precinct delegates being on the ballot. The party takes its character as a state agency from the duties imposed upon it by state statutes. The duties do not become matters of private law because they are performed by a political party. Heitmanus v. Austin. Here we go. The whole point of this is to destroy Heitmanus, which is this case that they, under complete bullshit, the Karamo people rest everything on. The court acknowledged an intra-party dispute as between the plaintiffs and Michigan's election law. That dispute was about delegates that either favored Bush or Kemp/Robertson. Heitmanus was in the latter camp. Despite the acknowledgement of the intra-party dispute, the court found the merits of the matter justiciable for two reasons. First, the dispute was fairly attributable to the state of Michigan because the state legislature, not the national party, set up the elaborate scheme of automatic delegates for county and state conventions. Therefore, the intra-party dispute was not a disagreement of a pure question of internal party policy. Secondly, the constitutionality of the Michigan election law was being challenged. The constitution of that statute was placed in question because Hypmanus and 4 other precinct delegates argued in part that the law violated their constitutional rights because the automatic delegates provision, statutory delegates, debased the voting rights of the elected delegates. Thus, the national party could not consent to a state statute that was facially unconstitutional. It's clear the defendants in this present case do not understand the Hypmanus decision. First, there's no legal theory as a Hypmanus doctrine. And it's doubtful that defendants are able to articulate such a legal doctrine. And again, I've been over this. I think I went over it in, I want to say that 10 days ago, Tuesday's live stream. The one I did where we were going to look at the Grand Rapids hearing, but we couldn't get in. So I talked about Hypmanus for a good bit. Bree Mogenberg makes the point, some precinct delegates are on the ballot. Others aren't elected at all by voters. They are voted in by other delegates to fill vacancies. You know, I might have missed this in reading it because I'm on stream, because I remember when I looked at the defendant's supplemental brief. Whoops, let me put this back on. Hold on. They did a footnote or something. Let me see here. Yeah, this. Okay, so it was at the beginning where they've made this nonsensical argument. Courts reject the circular reasoning. And then there's this footnote. The Kalamazoo County Clerk's list of GOP delegates shows that the plaintiffs claim that the defendants were removed from the party is inaccurate. To the extent the plaintiffs dispute the county clerk records, they further demonstrate this case is an intra-party dispute. Plaintiffs cannot use the subject of this dispute because there is no dispute. This is BS because the clerk is just a custodian of who wins the becomes precinct delegates on the ballot. They don't keep records of the official delegates that might be removed for whatever reason or that are elevated at a subsequent county convention. So anyway, where were we? Oh yeah, we were looking at the amicus brief. There is no such legal theory as Hypmanus doctrine, and it's doubtful defendants are able to articulate such a legal doctrine. Second, Hypmanus is cited in subsequent case law mostly for discussion of the abstention doctrine rather than justiciability of an intra-party dispute. The abstention doctrine in its line of cases pertains to whether federal courts can retain jurisdiction over state matters that may have similar parties in subject matter. Hypmanus, on the other hand, is recognition that justiciability of an intra-party dispute may be appropriate when there is one, sufficient state action or the claim alleged by a political party is based on a state cause of action, or 2, there is a valid constitutional challenge to rights. Significantly, Hypmanus Court established in its ruling that an intra-party dispute that is not a, quote, pure question of internal party policy may be sufficient for a court to rule on the merits of the matter despite the political nature of the dispute, if the facts of the dispute can meet several other balancing factors as to justiciability. Just because a matter poses a political dispute, it does not follow that it necessarily raises a non-justiciable political question. Cited. Similar to the court finding justiciability in Hypmanus, as to an intra-party dispute, there are several other Michigan state courts weighing in on judicial dispute resolution. For example, in Macomb County Republican Party versus Eric Castiglia versus Mark Fortin and David Langer. Remember that case, folks, in Macomb County? A dispute arose as to the rightful chair of the Macomb County Republican Party. The removed county chair, the defendant, refused to leave. Plaintiffs filed a motion for a TRO, and the court granted plaintiffs limited relief. The court ruled on various motions in the matter, including a motion for reconsideration and a motion to show cause. The court eventually ruled that the plaintiff was not the properly seated chair of the Macomb County Republican Party due to actions in the removal process violative of the county's bylaws. Significantly, however, the court did state in part, quote, to the extent Plaintiff Castiglia is planning to hold a Republican Party convention under a name other than the Macomb County Republican Party, defendants have not cited any authority that would preclude him from doing so. So, there was this case involving a question of who the chair was. The case was justiciable. And however, the court also said that because Castiglia did not call himself the same name that he's allowed to, Thus, the court noted that the plaintiff could continue with his plans for a Republican convention. That's actually a funny sidebar there, because Republican in quotation marks. One of the things that Kristina's people are also trying to do is to claim that they own the word Republican. That's part of the lawsuit against Comerica and the trust, which we talked about when we were looking at those documents. This decision balanced the constitutional arm with respect to the First Amendment's rights to freely associate with the state's interest in protecting customers, i.e. voters, in general form fraudulent claims of identity. Likewise, in Hillsdale County Republican Executive Committee, Hillsdale's not far from Kalamazoo, Judge Olsaver, sitting as presiding judge from Lenawee County, two competing groups claimed to be the official Hillsdale County Republican Party. In Hillsdale, a faction group similar to the present matter attempted to usurp the authority of the legitimate Hillsdale County Republican Party. Plaintiffs filed a complaint for declaratory relief, and the defendants responded that the court lacked jurisdiction to resolve the dispute based on the political question doctrine. The court determined that it had jurisdiction to resolve the dispute, and it ultimately entered a declaratory judgment permanently enjoining the defendants from those acting in concert with them from certain acts misappropriating the name or the business relationships of the Hillsdale County GOP. And I knew they were going to bring this up because they had to. Subsequent to entry of declaratory relief, defendants were brought before the court on an order to show cause why they should not be held in contempt of the court's order for declaratory relief judgment. For example, the faction group was ordered by the court to not use the name of the HCRP in its activities. However, the group advertised events as the HCRP. The court also ordered the Michigan Republican Party and its former chair, Kristina Karamo, to also appear and answer the contempt allegations. A hearing was held, and the court found that the defendants, including those acting in concert with them, such as the Michigan Republican Party and its former chair, in contempt. So they got that in front of the judge's eyeballs. That Kristina Karamo was held in contempt of court in Hillsdale. Why was she held in contempt? Because, like all these people, they don't believe the rules apply to them, even a court's order. On December 28th, 2023, the court entered its order for contempt of court and assessed sanctions, costs, and attorney's fees. I hope the judge reads this carefully. It's clear that inter-party dispute may be justiciable. In fact, the relief provided by the court in Hillsdale is similar to the relief requested by present counsel for the plaintiffs. Shazam. The facts. Distinguishing facts as an inter-party dispute. My throat's getting sore, guys. I might just skim through this a little bit. But this is where they're distinguishing between the cases they said you couldn't call the court, that were not justiciable, could not adjudicate, versus these other issues. And this is, again, it's methodical dismantling of the other side's arguments, what little arguments they gave. And finally, no intra-party dispute. The facts of the present case do not rise to a clear and definite intra-party dispute that is a pure question of internal party policy. To the contrary, the facts reveal the present matter relates to persons who are not even members of the official Kalamazoo GOP. Thus, there is no question of internal policy related to the dispute. The internal policy dispute was litigated in the case Your Honor, heard last year. The present matter, although related to some of the same actors as in the prior litigation, is not based on an application of an internal policy. This present matter relates to a group of discontent individuals who no longer have any association or relationship with the official KGOP. According to the KGOP bylaws, the fractioned off individuals are not dues-paying members, do not attend meetings, do not participate in fundraisers or Friday coffee meet and greets, do not man phone banks or distribute literature for candidates supported by the official KGOP. No, because all Kristina's people do, anywhere, certainly in my county, all the Kristina people do is try to destroy the party. That's all they do. Because that's what their agenda is. These undertakings include the payment of the organizations. Where was I? Yeah. Do not support the congressman and are willing to vote for a Democrat rather than their incumbent congressman, nor are they responsible for any financial I wish there was a citation for that, because I'll bet you somewhere they've said, screw this, Rhino, we're voting Democrats, so we'll get which you're entitled to do that, but not a thing you should really do when you're wearing your local GOP hat, okay? These fractioned off individuals form an unincorporated association of persons, initially calling themselves KZU delegates or similar designations. For a time, the group is now improperly referring to itself as the official KGOP. This dispute is not about ongoing internal policy regarding the official KGOP, but rather about usurping the name, identity, and statutory function of the official KGOP. Yep. So this goes on. And so basically they're making these two arguments. This is not about a dispute of internal policy, but outright misappropriation of the identity of the official KGOP. In the alternative, if the court determines that this second litigation matter between some of the same parties, such as and Pritchett Evans, is an intra-party dispute, Heit Manus does not preclude justiciability. Similar to Heit Manus, this present dispute is not a pure question of internal party policy. This present matter relates significantly to state causes of action that are viable because of the conduct of defendants and not the internal policies of the plaintiffs. Furthermore, justiciability in this matter is necessarily given that there is no other avenue for dispute resolution. The courts cannot reject as no lawsuit a bona fide controversy as to whether some action denominated political exceeds constitutional authority. The cases we have reviewed show the necessity for discriminating inquiry into the precise facts and posture of the particular case and the impossibility of resolution by any semantic cataloging. Conclusion. It is noteworthy for this court that the faction group is free to form their own political party. They can call themselves the Progressive Republican Party, the Party of the Constitution, the Party of Liberty, and so on. They can file a statement of organization. They can seek certification of their own political party. They are not prevented from organizing their own state convention, electing their own chair, recruiting delegates, or even going to a national convention. The prohibition as to their voluntary association of like-minded persons is that they cannot misappropriate or defraud the voting public that they are in fact the official KGOP. See the Macomb County case, see the Hillsdale case. This court has justifiable grounds to enter relief as requested by plaintiffs. And now the next heading, and this I think is going more towards the TRO element. We gotta get an order from you right now, Your Honor. If this court allows the faction group to continue to usurp the name and activities of the official KGOP, then all state county parties, regardless of party affiliation, will be threatened as to their survival. County parties are the lifeblood of politics throughout the country. These parties raise funds, recruit candidates, et cetera, et cetera. Many county parties lease office space, maintain databases, computers, cell phones, audio equipment, conference rooms, phone banks, serve as satellite locations for campaigns, hold meetings, train volunteers, train campaign workers, host events, coordinate strategy. Time, money, and millions of volunteer hours over the years, if not decades, have built county parties into an effective mechanism for achieving political success and enhancing outreach to voters until KKC will get in charge of them and then they destroy them. Most importantly, county parties work to achieve success to voting and the ballot box. Many county parties strive to network with their donor base to ensure that candidates and the political agenda for the party are maintained and advanced. The integrity of the county party is critical to ensuring trust and confidence in fundraising efforts, good relations with donors. See, this I would have all put up front. This is the common sense stuff. Donors will not give to a county party that is in strife or turmoil. And, you know, folks, look, I'm not a lawyer. I know that. I get that. There may be some reason I don't understand, but I'll tell you what. I work in politics. I work professionally in politics. That is a trade that involves persuasion. I have to be an expert persuader. So do lawyers. Big part of the trade is persuading. The mission of this brief is to persuade the judge. So that's how I would have done it personally. But nevertheless, it's still excellent stuff. Donors will not give to a county party in strife and turmoil. The threat to county parties statewide. The issue in this present matter is not that like-minded political individuals can't freely associate. Legal arguments in this case do not suggest that First Amendment rights should be restricted in any way. Rather, the issue in this case is whether individuals who have no relationship or association with an established political organization have the right to usurp the name and identity. Sorry, I just lost my place because I was looking at something in chat. Name and identity of a functioning and viable county party. If this court does not restrain the activities of the defendants, Halcombe et al. From misappropriating the good name and business goodwill of the official KGOP, then all county parties throughout the state of Michigan will be threatened with similar identity theft. For example, the court in Hillsdale did not hesitate to issue an order of contempt of court as against the defendants, including the state's former chair, Kristina Karamo, for their willful violation of its declaratory judgment, permanently enjoining the defendants and all other persons acting in concert or participation with defendants from, in part, conducting or attempting to conduct business on behalf of the HCREC or the Hillsdale County Republican Party unless they are elected to those positions in compliance with the bylaws. The RNC cannot enter and enforce contempt orders. The state party cannot enter and enforce contempt orders. The county party cannot enter and enforce contempt orders. But a court of law can. That is why this present matter requires judicial resolution and is justiciable. This court must stand in between those who engage in lawful political activities and those who unlawfully seize the identity of another organization in an attempt to further their political agenda. County political parties throughout Michigan will be threatened as to their survival if this court permits rogue persons with no legal authority other than their frustration with the fact that no one wants them around to take over established county parties. Of most urgency and importance to OCRP is this issue of trade secrets and financial data. In the present matter, the faction group not only wants to conduct political activity using the name of the official KGOP, but they also want to gain access to the assets of the entity. If the faction group gains access to the assets of the official KGOP, they will have access to the financial accounts and trade secrets of the official KGOP. This information is absolutely critical to a county party. If the court allows the faction group to operate under the name of the official KGOP, the next progression will be to take over the assets of the organization. For example, OCRP has invested tens of thousands of dollars into developing voter databases, which it deems its trade secrets. In case, the defendant Kuberski was sued in part for misappropriating the trade secrets of the plaintiff and employer of the defendant. The court relied on restatement of torts, section 757, comment B, as its starting analysis in determining whether information held by the plaintiff was a trade secret. Specifically, the court said, yada, yada, yada. Clearly, voter data developed for the purpose of voter registration or other get-out-the-vote activities in a specific county, like Oakland County, squarely falls within the Hayes-Albion Court's discussion of a trade secret. Rogue factions, if permitted to overtake county parties without lawful means, will have access to the trade secrets of the organization. Given the sensitive nature of data held by OCRP and other county parties throughout the state of Michigan, it is understandable that county parties are extremely worried about the outcome in this matter if a judicial remedy does not protect a county party like official KGOP from wrongful infiltration. Conclusion. The present matter before this court affects all county parties throughout the state of Michigan. The past 3 years or so, there have been attempts by discontent individuals and other persons to steal the identity of county parties. For example, see Macomb, Hillsdale, and now the present case. County parties need the assistance of judicial resolution to restore stability, security, and confidence in the political process through the county party system. Oakland County Republican Party submits this amici curiae because of the impact this court's decision may have on OCRP and other county parties throughout the state of Michigan. Respectfully submitted, attorney for Oakland County GOP, Margaret Kurzweil. Concurrence from John Dunlap, chair of the Washtenaw County GOP, Mark Fortin, chair of the Macomb County GOP, Mary Moylan, chair of the Gladwin County GOP, Jay Fedewa, chair of the Genesee County GOP, Rob Rodriguez Pellizzari, chair of the Livingston County GOP, Russ Jennings, chair of the Jackson County GOP. There you go. That's it, folks. That's what the court has to look at between now and Tuesday. They have a 3-page pile of shit from some new attorney who has probably no idea what this case is about because she couldn't even identify what role different members of her of her clients, what role her clients had in the case, because she's not representing the others, the local people, apparently. Penny Swan, PS Political News and Views, says, no one has paid their sanctions and fees here in Hillsdale. Yeah. Jason says, Marxist operative sickos. Yes, they are. It's becoming clearer by the day, folks. This is in response to Kelly Powell's comment earlier. Let me go back here. Bree says, Kelly Powell, our county has lots of open vacancies. They can be filled at county convention simply by the desire to film, and then the vote by county delegates to fill, I think she must have meant. Therefore, the majority of present delegates at the county convention can further stack the delegate pool by simply voting in to fill those vacancies. Well, let's be clear, folks. You can fill precinct delegate vacancies at a county convention, but only at the end. They can't show up at county convention on Thursday and get to be elevated and get to be voting members of that convention and get to have precinct delegate preference over non-PDs. No, because the state party rules, the state party's convention rules say, and have said since 1988, in no event can any precinct delegate vacancy be filled on a temporary or permanent basis until all of the choosing of the delegates to the district convention is completely finished. Anyway, so Kelly says, I wish I had a crash course as a new delegate in 2016. Ironically, same time in district as KK. There you go. And then Bree says, I know, I'm trying to share And, heart, 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 XOXO. I'm trying to share more for those who weren't aware. They constantly talk about we the people, but in fact, literally could be we the delegates. It's deceiving. Yeah, these people, all of them they're all come latelys. They were never involved in the Obama years, or even in 2016, 2018. Kelly Fountain asks, what stops Democrats from becoming a delegate? Nothing. In the Ron Paul campaign days in 2008, I recruited some Democrats to become Republican precinct delegates. Why? Because at the county convention, they would vote the way I told them to. They thought it was fun. Just saying. Well, and the next thing's to me, they're going to take that clip and say, look at this rhino. See, he clearly is a Democrat. No, because I wanted Ron Paul to be my nominee in 2012. That's why I did that. See, that's how this works. Penny Swan says, no one cares about what the courts say. Those individuals that were found in the wrong do what they want to do anyway, just ignore it like they did here in Hillsdale. Well, we'll see how far this goes. They've gotten to an order of contempt of court. I don't think they're going to get too much farther. You don't. I mean, we'll see. We'll see. Bree Mogenberg says they wanted counties and districts to have, quote, bylaws that are robust and uniform. Interesting. Okay. All right, guys. That'll do it for us for tonight. On Rumble, Charlotte Cosmic says, gosh, if they only did something like this with the 2020 convention. Yep. Well, and by the way, folks, that was why Trump hired Paul Manafort to run the 2016 RNC, because he was an expert at preventing convention shenanigans, which has happened all the time at national conventions. You want to read the history of that? Buy A Choice, Not an Echo by Phyllis Schlafly on Amazon. Get a new edition because it was updated in, I want to say 2016, or right before she died. And it's got the history of all the Republican national conventions from like 1912 to 2012. It's fascinating reading. A Choice, Not an Echo by Phyllis Schlafly. All right, folks, that's it for us for tonight. We will try to do another stream sometime tomorrow, and then certainly we'll have a stream on Sunday. And at some point, we will definitely cover some of the other news of the world. Until then, thank you guys for everything you do for liberty.